Yeah. One thing is Bahujan's History Month is celebrated in order to remember our uh, ancestors who have fought for social justice, who have fought for social change, and who have fought for basic rights of our communities, Bahujan communities. And also, like there is a celebration of Black History Month in US. There is celebration of Dalit History Month in US. But going on the lines of Kanshiram, Manyor Kanshiram, whose birthday anniversary we have recently celebrated. Kanshiram has always reiterated for a larger term of Bahujan including SCs, STs, OBCs, and religious minorities. So the thing is, India right now needs this Bahujan ideology or Bahujan umbrella where all the communities can come together and fight for social justice, fight in politics and everything. So this is what Kanshiramji has envisioned. Kanshiramji has envisioned to bring 85%. There is a song in Telugu, Notiki Anavaidu Kutigi Leni Vallu, meaning like there are 85% of people, SCs, STs, and OBCs, who uh, are larger in number in the Indian society, but who don't even have basic food basic food to eat every day. And also, so that is the reason, like as March 10th starts with Savitribai Phule's death anniversary, and April 14th ends with Baba Sahib Ambedkar's birth anniversary. We thought that it is important to remember these our ancestors who have fought for social justice, like Jyotirao Phule, uh, Savitribai Phule, Kanshiram, Manyor Kanshiram, Ramabai, uh, and Ramabai, and all other ancestors of ours, our fighters of social justice, to remember them and to celebrate under a common umbrella term, Bahujan. So that is the uh, uh, idea of celebrating Bahujan History Month. So the current talk that we are having, whose law and whose justice, rethinking law from Bahujan perspective. The thing is, like, as we know, there are many say laws which are there to help Bahujan communities, SC system. There is SAST Atrocity Act. There are many other such laws. But every day in Indian society, SCs, STs, OBCs, and religious minorities are every day deprived of these rights, the basic rights that have been given to us by the Constitution of India. So there are two justice that always run through this country. That is, the rich get one justice, the poor get one justice, the upper caste get one justice, the lower caste get another justice. That the kind of justice that they get. The people who have money get justice in this country, but the people who don't have money don't get justice in this country. As we have seen in many movies also, how the movie JB portrays how justice, how tribals, people who don't have basic needs to survive, are pulled into some sort of cases and put into jail, killed. And these things happen every day. These have become common sense to us, common sense to us every day. So instead of looking these as separate events, instead of looking these as happening to SCs, happening to STs, or happenings to now we can see how on the idea of that protecting cow and these things, how uh, uh, say how Muslims are being attacked every day in this country. Muslims are being attacked on the allegation that they are transporting cow, they are eating beef and these things. So basic rights of these communities are being deprived day by day. So in this aspect, in this context, we thought that it is important for us to understand law and justice from Bahujan perspective. Even in the recent incident that portrays how a shoe was thrown on Chief Justice of India who belongs to the Bahujan community. So this shows even if you are at the highest order of justice, still you will be you will face caste discrimination in this country. So in this context, I would like to invite our two guest speakers of the current session, Dr. Asang Wankhede. Dr. Asang Wankhede is a PhD awarded PhD from University of Oxford. He also was a member of Australian Human Rights Commission, and also he has worked in many other firms, and currently he is an advocate who is specialized in anti-discrimination law. Welcome you, sir, Asang sir. And the other speaker today we have is Professor Arathi PM. Professor Arathi PM, assistant professor at Dr. Arathi PM is an assistant professor at Mahatma Gandhi University. She her work involves involves the intersection of gender, healthcare, and these aspects, legal thought, gendered bodies, and medicine and law. So her doctoral research was on gendered bodies, medicine, and law. She has and her MPhil thesis was on aborting gender justice. So ma'am works in the intersection of law and gender and law and justice in this version. I heartily welcome you, ma'am, for this current session. Now I request Dr. Asang to take over. Yeah.
Thank you. I hope everyone can hear me.
Yes, sir.
Yes, we
Yeah.
can hear you.
Thank you. Yes. Jai Bhim, Salam. It's a great honor to be invited on this day, especially today. As all of us know, the significance of this day, I will not reiterate because I have about 15 to 20 minutes to engage on this very important topic. Who's law, who's justice? And I'll start with saying a few things. And the first thing is that I wasn't part of the Australian Human Rights Commission. I executed their project of caste in Australia. So that correction is important there. I was not officially working for them. But my engagement in Australia in the diaspora of anti-caste discrimination informs us that caste is not only limited to the South Asian subcontinent, but is a global phenomenon. Dr. Ambedkar, way back in 1930s, have informed us that wherever Hindus would migrate the face of the earth, caste would travel with them. But especially today, this topic becomes so crucial now that we are, of course, commemorating the 99 years of Mahad Satyagraha and also the Jaipal Singh Munda's death anniversary. What has changed since Mahad? What has happened since Mahad? I'll first try to cover that aspect. Second aspect that I will try to cover is the warning Dr. Ambedkar gave while giving us the Constitution of India and the many contradictions, the lack of contradictions that we are entering into in process of accepting this liberal transformative constitution that he played a major role in drafting. And finally, sort of to conclude, to call upon reflections from all of you, where are we going and what is the question of justice? What is the problem with when it comes to achieving that concept of justice and how Dalit Bahujans are at the receiving end of the justice system, be it the criminal justice system, or for that matter, the other social justice system within the country as well. Baba Sahib was very clear, and that the way to approach independence and to have our own life and be the destiny, uh, be the be the shapers and the writers of our own destiny. A good liberal constitution with a set of strong fundamental human rights, where anti-discrimination norm is at the core of those fundamental human rights in Part 3 of the Indian Constitution, would be a good approach. He, and as we one reads the debates of the Constituent Assembly, it becomes amply clear that the debates of back and forth that had happened was that we wanted to move away from the past of riddled with untouchability, the practice of caste discrimination, the worst form of social exclusion for thousands of years that the Dalits face and even now continue to face. And furthermore, also redefining and having a vision for our Indian society as the one that is a transformed one and not and that does not rely on the previous, the old uh, society and system, which did not consider humans as humans. There was no sense of equality in the society of women in particular, but also treated at par as untouchables in many instances. And I can just go on and go on. Baba Sahib's Life of Contradiction speech on 25th of November 1949, Dr. Ambedkar was acutely aware that a constitutional framework would grant liberty on paper, while society denies it in reality. And this is the contestation between, on one hand, the formal set of rights, as we recognize it, the formal language of rights and laws, and those anti-discrimination laws and criminal law protections against casteism, gender-based discrimination, etc., on one hand, and on the other, the societal acceptance or non-acceptance of the same. While he spoke throughout the drafting committee process, his famous warning regarding this life of contradiction, of course, came on the 25th of November. And I quote him, he said, I quote, opening of the quote, on the 26th of January 1950, we are going to enter into a life of contradictions. In politics, we have equality, and in social and economic life, we have inequality. In politics, we will recognize the principle of one man, one vote, one value. In our social and economic life, we shall, by reasons of a social and economic structure, continue to deny the principle of one man, one value. And he just followed with this haunting ultimatum for the future of the nation and to us as people who read his speech from back then. The ultimatum to all of us was, how long shall we continue this life of contradictions? How long shall we continue to deny equality in our social and economic life? If we continue to deny it for long, we will do so only by putting our political democracy in peril. End of quote. A key takeaway from this aspect is a call for reflection for all of us, for the members of the audience, for me, uh, my colleague who is joining and who will go after me and give the speech. The idea that we have achieved democracy in the real sense, the idea that we have achieved rule of law in real sense, and that the idea that we have already achieved an equal society in real sense, just by adopting the formal language of rights, needs to be further investigated. I call upon all of you, of course, to ask these questions, but my uh, you know, intervention here will be to argue that we have not achieved it. And it's not a secret. People who are attending this call would be very much aware about the atrocities, the violence that minorities in India continue to face, women and the status of women in the society. What is the key takeaway for us is how do we build upon that haunting ultimatum Dr. Ambedkar gave us in 1949, and in the last 76 years since that, what is the progress that has been made. The progress that has been made, a positive aspect, has been that we have seen that untouchability as a practice has largely gone away from the urban centers. What we have seen is that at least formally we have a set of um, anti-discrimination laws for scheduled castes and scheduled tribes in terms of the prevention of
వీళ్ళకి
atrocities.
ఏమైందంటే
Could you please mute whoever is that one? Sorry. Thank you. We have before us a great set of laws, for example, the Domestic Violence Act. At the same time, we have other non-discrimination, anti-discrimination provisions, etc. And we have this jurisprudence of the Indian Supreme Courts, which has been, for what it is, a progressive one, recognizing through its public interest litigation jurisprudence, expansions, and the interlinkages between different sets of rights, be it right to life with untouchability provision in the Article 17, be it the non-discrimination provisions and liberty provisions under Article 19, so on and so forth. The point that I'm trying to convey is that if we look at the formal set of rights and laws that exist in India currently, it is very clear that we have a good set of laws. I am not trying to whitewash the many contradictions and problems that some of the provisions within the existing exist. For example, the Manual Scavenging Act. My legal analysis and work on this aspect of manual scavenging calls for a complete overall, a complete changing of this particular legislation because it has it tries to achieve ending of manual scavenging. But what it in turn does in reality is that it perpetuates it. My analysis points out that just by bringing up a new legal fiction of sanitation workers, of gloves and protective equipment, manual scavenging stops being manual scavenger using the language of law, using the very language that is meant to safeguard, rehabilitate, and protect manual scavengers. But the point that I make here is that there is a gap between this progressive set of legislations that we see in India and the actual implementation of it. Many of you would just know that, yeah, there is a gap. And many of you would want to then just ascribe that gap to the lack of political will. It is my understanding that that is a very narrow way to look at this whole aspect of that, oh, it is only a lack of political will. What it devoids us is it stops us from discussing what are the issues of structural discrimination, structural violence, the structural inequality, and that continue to persist despite 75 to 76 years of affirmative action in India, reservations, and other affirmative action policies. And more fundamentally, anti-discrimination law, criminal laws, which criminalize any form of violence against their own natives, the minority Muslim community, of women, Dalits, etc., and tribal populations, of course. What is very clear from all of these sort of developments is that the gap which exists is an intentional gap coming and generating, evolving from the structure and the structural discrimination that exists in our society even after 75 years of these progressive laws being there. Now, of course, the legal framework, often assumes a level playing field, right? And the implementation criteria is that the bureaucrats and the very machinery, the prosecution machinery, the police machinery, which are tasked with, have been given the power to implement this legislation, are themselves casteless, are themselves discriminate. And there, of course, that is one of the approaches that we can have to understanding what is happening. But when a Dalit woman, for example, or a Dalit queer person approaches the criminal justice system for justice, what they are encountered with is humiliation, is non-recognition, rejection, and at the same time also further criminalization. So a society which already subjugates, already oppresses the most vulnerable within the society, the only avenue that they have is to go to those criminal justice system to get justice and redressal. The outcome of that, unfortunately, is that they are made to suffer for. They are made to that is that the issue of casteism is so further entrenched that there is double discrimination that individuals, and I hate the word victim, I would say survivors, continue to face. And I think in the last 5 minutes, so to speak, to wrap up, I would also sort of, bring up the theories as we understand about structural racism from outside of India. In the current times, we have seen a complete assault on any progressive piece of legislation, be it the UGC guidelines, as many of you would be aware about, and the whole anti-UGC guideline brought us the sad treatment of that and the stay by the Honorable Supreme Court uh, on that guideline, claiming that it will lead to a caste society. It will further entrench caste in Indian society and that we cannot achieve casteless society. I please request everyone to mute themselves. Thank you. Yeah, please mute yourself. Thank you. Yes, policy regulation. But what we see in the US context is a body of literature that I think you should read if you're interested in this topic, which points at few things about what is the basis and the fundamentals. What is the underlying objective of this opposition to any progressive piece of legislation which wants to achieve anti-discrimination? What is the underlying basis of the opposition to affirmative action policies? It is inherent, entrenched racism, of course, in the US context, and in India's context is casteism. But to understand that the upper caste groups who choose to use caste for their benefit in multiple ways have the luxury and the power, is a question of power, have the power to deny the existence of caste as and when they feel it's in their benefit to deny their existence, and play the proletarian, the subaltern card whenever they think it's in their benefit. But at the same time, can also use that caste benefit and privilege that they are born with to continue the structural discrimination, continue to further the systemic discrimination. The denial of the reality of caste discrimination and gender discrimination and religion-based discrimination is a form for the oppressor to establish their power again in the society. The denial comes at the cost of not looking at the empirical evidence, which tells us, both in the US context as well as in India's context, that the enduring fact of our societies are racism and casteism. So any person who claims against that fact, the fact is empirically established, anyone who opposes that aspect is not only is in a denial mode, but is a perpetrator of that systemic discrimination and racism. Now, in the last 2 minutes, come about this. Right? Dr. Ambedkar has given us a blueprint, which we haven't, even with the states ruled by Bahujan leaders, even the states ruled by our, quote unquote, our people, have not included is an imagination, a vision for a radical social transformation. Radical social transformation cannot happen by mere formal set of laws and rights. A formal set of laws and rights are incapable by the very nature of how the legal systems work, the very nature of how laws are accepted and further, that that laws cannot achieve that lasting structural emancipation and change. They can play a central role, and as we can see, Constitution has played that central role in trying to oppose a lot of nonsense that was happening in our society, a lot of entrenched structural issues. But the actual struggle lies in using the instrument of law to also then use that as not the panacea, but as the important foundation, the rule of law as an important foundation, the constitution as an important foundation, but also undertaking the actual work of social transformation at the grassroots. My engagement at the grassroots has been because of that I realized when I am and I'm currently a student of law, I will be for the rest of my life as a student of law, that law has only certain limits and certain potential. And the actual social transformation can take place only when the cast of mind, the mindsets of individuals who are so prejudiced, and not only based on caste, but on other grounds, etc., changes. And that has happened in other jurisdictions, not the uh, utopian uh, aim that people might have of a casteless society. What the Honorable Supreme Court has time and again said, that we need to achieve casteless society without even telling us what that means. But the point is that our steps as youngsters should be towards a social transformation, which is rooted in the language of law, but which doesn't consider law as a panacea, as the ultimate or the only source for achieving that social transformation. I will stop here, and of course, we can have a brief Q&A. And to the organizers, I'll have to leave in about 30 minutes because I have another engagement. But thank you for giving me this opportunity. And it's always exciting to be talking to the students of SC. Thank you, and Jai Bhim and Johar.
Thank you, sir. Thank you so much for joining us. So basically, you have helped us to go through the intricacies behind the law and the politics behind it. Despite having the law, it doesn't have the full potential in order to social change. But the what really we need to have to is to work on the social conditions that are happening in the society. Maybe in terms of the inequalities that are reproducing in the society. And we have also helped us to know the potentiality of the law, as well as it intricacies and the politics behind not having the works that are there, despite having the power of the law. So basically, you have helped us to know the systematic discrimination that has been perpetuating. But the problem for this, the solution for this problem happens through the changing nature of the mindset. Yes, sir. We, as a student organization in HCU, we are working, and in this month, starting from this month, 10th March to next month, April 14, we are conducting a series of events in this Bahujan History Month, where we are introducing many anti-caste thinkers and their philosophy to the student community, so that it helps us to know the intricacies behind the structural operation of the society. And yes, thank you so much for this, for accepting our invitation, sir. And next, I am introducing Dr. Arathi ma'am to share her opinions.
Hi, I hope I am audible.
Yes, ma'am, you are.
Okay. Thank you so much, BSF-HCU, for this opportunity to be part of this discussion. And I'm really glad that I got this opportunity to listen to Dr. Asang Wankhede too. And let me quickly approach this topic from a methodological point of view. Definitely the title of it, Whose Law, Whose Justice? We know that these laws are not absolutely meant for us, and the justice is not delivered the way which we wanted to. So definitely we wanted to rethink law from a vantage point which is given by the perspective of Bahujan ideologies. So I wanted to approach this topic from three major point of views. One is when we are discussing about the very nature of law, we consider it as a value neutral thing, and we consider law as it has a universality in its application because it consider all the people equal, and that popularly we denote it as equality before law. By stating equality before law, the popular assumption is that it is applicable equally for all the citizens or all the people of this country. And then the very idea of value neutrality of it, uh, value neutrality of law, which gives an idea that it has its own objectivity, and there is no subjective biases in the process of administering justice. So, by considering these two aspects, primarily we need to methodologically challenge the universality and value neutrality of law. And second, I think we need to revisit all the protective legislations of this country and to assess the effectiveness of it. I think Dr. Wankhede was suggesting towards how affirmative action laws and policies and effectiveness of it. So I think this is the time we should sit together and go through all the legal texts of this protective legislation and see that how effective these are. So I also agree with Dr. Wankhede by saying that these are progressive legislation, but the problem with the implementation. All my undergraduate students used to write their assignments in that line. And I think that actually covers the structural discriminations, structural violences, and inequality based on structural discriminations. So we need to look into these protective legislations and see how far the very content of law itself is successful or how it get failed to address these questions of uh, addressing historical discrimination through protective legislation. And finally, the third aspect is I wanted to uh, specifically look into the judicial process, especially higher judiciary, and including the uh, lower judiciary, to look into how this judicial process itself is so biased when we are discussing about who's law and who's justice. Because in our everyday life, though the law being effected and implemented through the court administration of justice, through the court judicial process. So I think the biases of judicial process itself we need to look into. So initially, I wanted to mention that when we analyze who's laws and who's justice from a Bahujan perspective, we need to challenge the universality of law, primarily challenging the value neutrality and objectivity of law. Secondly, we need to revisit the protective legislation of this country and to analyze how far this is successful or why it's getting failed to address systemic and structural inequalities and discriminations. And finally, we need to assess the judicial process and judicial biases, how the criminal justice system and the judicial process itself is biased, and how it is become condescending when it comes to the questions of social justice, gender justice, and the rights of human rights of marginalized sections in our country at this particular point of time. And I may probably heavily rely on one of the texts which I have been reading of late. This is the book titled Incomplete Justice, the Supreme Court at 75 Critical Reflections, edited by Judge S. Muralidharan. And it has a lot of, it offers a lot of perspectives, critical perspective towards the functioning of judiciary, and in which one of the articles which I would like to focus in today's presentation is by Professor G. Mohan Gopal. He is looking into the very casteist nature of Indian Supreme Court. So these essays are at the 75 year of Supreme Court of India, and critically evaluating how far these Supreme Court of India is successful in protecting the protecting social justice. And some of the articles by Usha Ramanathan and Indira Jaising, they are looking at the issue of gender justice and how gender biased Indian judiciary is. Mohan Gopal sir is critically looking into the caste bias of Indian judiciary. I initially, for a few minutes, I'll focus on his work, of late work, and to explain how far Indian judiciary is casteist. And Indian Supreme Court in of late last 75 years of Indian Supreme Court reiterated the caste discrimination, rather abolishing the caste-based discriminations. So in his work, he was looking into how Supreme Court of India has protected and preserved the caste system. And it has been an anti-catalyst in two ways, he argues. One is suitably by redefining three foundational legal concepts like caste, religion, and the idea of Hindu. And second, by kind of eviscerating reservation, which is conceived by Dr. Ambedkar, is the intended constitutional weapon of caste destruction. So the Dr. B.R. Ambedkar's idea of how constitution can be used to do the caste destruction and how that process got failed. And Professor Mohan Gopal consciously arguing that there is no general accepted definition of caste. If we want to methodologically or theoretically approach this question of whose law and whose justice from a Bahujan perspective, I think we need to have a common understanding about the definition of caste system. And Professor Gopal tries to offer a new definition from a legal point of view to the caste system. So this definition distinguishes between social groups, communities, and organically formed by individual by coming together on one hand, this idea of communities, with that of Varna Jati category that is imposed top-down social group on another. So he was arguing that interchangeably how in the initial days, even the interpretation of courts, which is used the community idea of community with that of Varna Jati category. The caste system, that is Varna Jati system, he defines as a political system of governance that vests and diverse civil, political, social, and economic rights of individuals through a three-part process. One, individual rights are derecognized and extinguished, and rights are limited to group rights derived exclusively from social groups to which parents of a person belong, and change of social group is prohibited. Secondly, social groups in turn are categorized into 5 hierarchical, that Varna categories. And these categories are 1 to 4, that except Shudra, vested with varying degrees of civil, political, and economic rights and privileges, whereas category of 5, that communities are divested for all rights and privileges and are instead of placed under numerous civil, political, and economic liabilities and disabilities. They are stripped of their humanity and citizenship. The final authority to decide the categorization of individual social groups, the roles, the rights, liabilities, and disabilities of members of each category, as well as the relationship between categories, is controlled by the first category, that is the one category which is top in the Varna system. So the intermarriage between categories or change of the category into which one is born is prohibited. The total stripping of individual group and group civil, political, and economic rights of the population placed in category 5 enables their unhindered social, economic, and political exploitation. So the caste system, thus an oligarchy, he argues, ruled by few categories of 1 or 2 of the vast majority of the people, that is the category 5. And in effect, Varna Jati system is a system of unequal citizenship. That's what he argues. So I think throughout the argument, when we start thinking of whose law and whose justice, I think this should be the primary foregrounding argument which we start with. In effect, this Varna Jati system is creating an unequal citizenship. And when we are discussing whose law and whose justice in an unequal system of citizenship, definitely it has multiple layers, and it itself, the system itself, law itself can perpetuate discriminations, and it can reinforce hierarchies. And when during the, if you look into the Constituent Assembly debates and all, we know that Dr. Ambedkar, who demanded for total annihilation of caste, Varna Jati system of divesting rights through categorization of communities into these 5 categories. Which is, we can see the reflection of it in the Constituent Assembly debates. Those who are Ambedkar and his colleagues used to argue that Constitution has a powerful provision to help in the goal of annihilation of caste, which Mohan Gopal liked to term it as a weapons of caste destruction, and that are vital to sheet anchor the democratization of Indian social order. It's not only addressing the rights of the caste-based underprivileged sections of the country, but it also aimed to democratization of our social order and advancement of social justice. So I think Asang was mentioning about Article 17, 25 and all. So if we go through the constitutional provisions, we can see that 17, which forbids, criminalizes the practice of untouchability, 25 is the freedom of religion, and Article 15 clearly talks about prohibition of caste-based discrimination, and 16 prohibits discrimination of religion and caste when it comes to the employment and entry to the offices. 29(2) prohibits discrimination with respect to admission into any educational institutions and all. So we see that there are a lot of, where I wanted us to revisit these constitutional provisions along with the particular legislation existing to protect the rights of caste-based underprivileged sections of our country. That is what the methodological responsibility of academics also to through our work we can clearly show that how the existing law and its biases, also the existing protective legislation, and how it fails when it comes to the in terms of temporality, how it fails to address the questions of social justice of our time. And even one of the arguments about in Mohan Gopal's work, he is arguing how religion being addressed. And he was going through a lot of Supreme Court judgments from last 75 years. And he argues that Supreme Court of India approach to caste closely mirrors the Vedic Brahminical axiology that preserves Varna as a laudable social order. So you've been citing a lot of case laws like State of Punjab versus Devinder Singh, and so many other case laws. And his argument is the Supreme Court of India approach to the theory of caste does not pay attention to any of the anti-caste movements in this country. Rather, it actually resonates the existing Vedic Brahminical axiology. So say, for example, he was citing Narayana Guru of Kerala, according to Guru, the jati means a janma riti. It's a way of practice, mode of birth, making it synonymous with species. and he calls it as Homo sapiens as the only one method of birth, and all human belongs to the same jati. On this basis, Narayana Guru calls for total rejection of all claims of jati differences as they amount to an attempt of subspeciation of human being. So if you look into Article 38 clause 2 of the Constitution calls for equality between groups. Social groups should be free from and transform their members wish the function in accordance with the core values of liberty, equality, fraternity, and dignity set out in the preamble of the Constitution. So this view both complementary to Dr. B.R. Ambedkar's call for representative democracy on the basis of due and adequate representation of all communities in sync with the constitutional vision. So when we look into the socio-political atmosphere of today, we have to critically rethink where we are when it comes to the representative democracy and that as a core constitutional value. So when we discuss whose laws and whose justice, I think this is one of the vantage point in which we can ask these questions, especially from the framework of representative democracy. So in this work, Dr. Mohan Gopal discusses about between these various judgments of like a lot of judgments. He discusses this and then he argues like Ramesh Yashwant Prabhu versus P.K. Kunto and all. Between these various judgments of Supreme Court of India, we see a merging idea of Vedism, Brahmanism with the idea of Hinduism. So if you look into the definition of Hindu, according to the Constitution itself, it submerges all other Sikhs, Jains, and all as part of the definition of Hindu. And of late, all these Supreme Court definitions, which shows that the Brahmanism with the idea of Hinduism, and in the past probably a decade, how the existing values of the union government, which is getting resonated and reflected in the Supreme Court of India, we can see that Hinduism as the idea of Hinduism merging with the idea of India. So you see that how far we moved from the Constituent Assembly debates and defining like Hindu as Vedism, idea of Vedism and Brahmanism with that idea of Hinduism, and then Hinduism merging with the idea of India. So that's why I think this question is very, very important in today's context. So you merge when the Supreme Court of India itself is trying to merge the idea of Hinduism with that idea of India, then I think it's an alarming situation in which we cannot be very naive and see that law is applicable for all and universality of law and equality before law, that is the constitution value, which we cannot sit back, but we have to actively think and discuss and to especially when since we are in higher education institutions, to focus our own work more into challenge these interpretations and values which is produced by the judicial process itself. So I'll take 5 more minutes to conclude my presentation by focusing more into the idea of gender justice. And so here I always discuss with my students, and in my presentations, I argue that we cannot distinguish between gender justice and social justice as two different things. So these are very, one, I would consider it as a single category, and one is the subcategory of the other one. So when we discuss about gender justice, considering women as a homogeneous category is always before law, we see it as a huge limitation. So whatever legislation we have here to protect the concept of gender justice, we can see that they consider women as a homogeneous category. So the very ideas of Dalit Bahujan identities, which is completely is not discussed when we are creating any protective legislation only for the idea of gender justice. So the intersectional identities of women of caste, class, along with their religious, regional differences, how law could address these differences and the heterogeneous category of women itself. And it become even more complex when it comes to the sexual orientation and the question of sexual identities we merge with the idea of gender justice. So I think we need to critically look into starting from the constitution to all the protective legislations existing in this country. Say, for example, can we look into the PWDV Act, Prevention of Domestic Violence of Women, or POSH Act, Prevention of Sexual Harassment at Workplace Act, and see what are the problems with these legislation by considering women as a single homogeneous category. When it intersects with the class question, when it intersects with the caste question, and when it intersects with the class and caste question together, along with the religious question and the regional variation, then we could identify why the structural discriminations are not being addressed through these legislation. Though the interest of the law is to protect the rights of women, to ensure gender justice. But as Asang was pointing out, the gap, the progressive laws are here, but why is it lacking actual implementation? I still remember as a student of law listening to Professor Upendra Bakshi saying that there is no such law in this country which is good in content and difficult in implementation. If it is difficult in implementation, that means there are some problems with the content and the text of that law itself. So we need to critically analyze the laws from looking into the text of the law, looking into the judicial processes, even the parliamentary processes, what are the objective, what are the legislative intent of certain legislations. The very legislative intent, we can see that the caste biases of Indian Parliament and gender bias of Indian Parliament. So the parliamentary process itself, we need to look into the parliamentary debates of certain protective legislation and see how far the legislative intent itself is biased and the law itself is biased. And we need to look into the judicial process from that point of view. And basically, I would like to conclude by saying that when we are looking into the very idea of justice, basically, we need to look into the idea of access to justice. Primarily, probably I'm borrowing from Hannah Arendt and saying that right to have rights. We have rights mentioned in this so-called progressive legislations, which is protecting of vulnerable and marginalized and historically discriminated categories of this country. But if they are not implemented properly, then we need to think about what are the problems, why we don't have right to have access to these rights, since rights are there in the law, but we are not able to access it. So this access to justice is a major critical point which we need to analyze. Definitely, we need to look into not only judiciary and the judicial process, we have to look into the criminal justice system. Asang was mentioning about how the further criminalization happening when we are approaching to the criminal justice system. Probably that is a story we hear from many part of this country, how police deals with the deprived sections of society and people from the Dalit and Bahujan communities, the women, the children, the workers from such categories. So we need to critically look into the criminal justice system, then what are the biases of the system itself and the judiciary. And finally, we need to look into the social support systems we have. Where are we lacking it? Why this? Not only the societal attitude, we live predominantly in a caste oppressed society. But within our own communities, do we have systems of social support? Why the democratic values of our system is not within the communities and within the larger societies, where are we lacking? So that self-reflection is also very, very important, I think. So basically, especially since we are all are from the university and higher education system, I think we need to focus how are we going to address these issues. First of all, I wanted our academic work to identify inherent biases of law and the judicial processes and the criminal justice system. And secondly, I want us to expose it through our academic interventions. Our own research should reflect upon these questions, first of all, to challenge the value neutrality and objectivity of law and the judicial processes. And second, to Asang was mentioning it slightly, and I'm thankful to him. This law's transformative potential, and we think that every issues can be addressed through law. No, so the transformative potential is very limited. And to identify that, we need to understand and identify the inherent biases of law and law itself, how it acts as an oppressive tool to oppress the caste deprived sections of our country. And I, I wish you all to uh, work towards such kind of an academic intervention in whichever area you are working on. Develop a critical lens towards the very idea of law. Don't ever take it as a value neutral entity, and see it as how the law itself and the judicial process itself is furthering the existing socio-economic discriminations, structural discriminations, and structural violences, and develop a critical framework to address that. And let's have a strong methodological ground here by doing more qualitative research and more interventional researches at this to identify these issues in our time. Probably that is the way in which we do justice to ourselves and justice to the system which we are part of, and also justice to the ideological propositions which Bahujan History Month is actually intended to explore. Thank you.
Thank you so much, ma'am. Thank you very much for helping us to travel through the basic idea of the Indian judicial system, the basic idea of its nature, and how it is caste and gender based. Based on your based on your insights, I can remember of Dr. Ayyappan, who is a social anthropologist from South India, who's saying is that Aboriginals are strong in the constitutive side, but weak at the executive side. Yes, this is the basic thing that we have been seeing in the everyday realities of the Indian judiciary system. The recent incident of the Justice Gawai's incident as well, and everyday incidences that are happening in the villages. Though there is clear evidence from the marginalized communities, but the law and the police behind the law is very much at the front in masking in masking all these things. Also, thank you for helping us to travel through the works of some of the academics that are related to the law and their works, and how to understand the law in terms of their understanding. Uh, and also, you helped us to critically think about the law. Like, it's not just a neutral thing, but there are biases in it, and there are certain hierarchies in which we can understand the law. Yes, ma'am, through our works, somewhere we can include the law and think it critically, not just a neutral thing, but we will think in such a manner that to challenge the possibilities in bringing social transformation. And thank you once again for joining us, ma'am. And now the floor is open for question and answer. If there are any questions, please feel free to ask, or else you can type in the chat box.
Someone has posted a question actually in chat. Ma'am, can you see the question?
Let me just check.
Yeah, please. If anyone has any questions, please raise your hand, or you can just type out the question in the chat box.
Yeah, the first question is I can see is regarding the just a minute. Reasonable restrictions, right?
Yes, ma'am. That's the question. Yeah.
Yeah. So I think we always challenge the very idea of reasonableness, as the title of today's talk points out, is whose reasonableness, who fixed that standard, whose standard is considered as reasonable, uh, reasonableness or reasonable too. And in that way, I think this is the major criticisms of uh, the feminist scholars always is the reasonableness is the reasonable man, and especially a reasonable elite Brahmanical man. So many of the reasonable restrictions, which is now turning into something curtailing the basic freedoms. So it has been always a debated terrain when it comes to reasonable restrictions. But I think the very idea of reasonable restrictions we may have to challenge, particularly asking the question, the who defines the reasonableness, where you whose standard you're fixing, whose point of view is that reasonableness comes from. Definitely reasonable man, and reasonable, who that man is definitely from the upper class, upper caste, uh, urban kind of a idea of reasonableness is reflecting upon when Indian judiciary defines what is the reasonable restriction when it comes to freedom of speech and expression. And we see that how much they are worried about the institution of higher education, and even our own academic freedom is part of Article 19(1)(a). And UGC is restricting us that these are the areas of conferences and seminars you have to organize, and these are the areas you shouldn't be doing. So if you take certain positions, you can easily be an anti-national in an academic domain nowadays. So reasonableness, my point is we have to challenge the very idea of whose reasonableness it is being interpreted as reasonable restriction. And something, I cannot go back to the chat box because of some issues in my phone. Can someone read out for me, please, the next question?
So if law is considered as an instrument of justice, how do we explain situations where it reinforces social inequalities instead of dismantling them?
Yeah, I can take it as well quickly.
Yes,
Yeah,
sir.
yeah.
Yes,
Please,
sir.
Asang, Dr. Asang.
Yes. No, I think that's unconstitutional. The one word that immediately comes to as a response is that how do we explain situations? It's you have to call them as unconstitutional. So just because a particular law exists doesn't mean that it does more harm. Sorry, it does more good than harm, right? I think in the case of Manual Scavenging Act, uh, again going back to that, what we have seen is it was hailed by the Indian Supreme Court, 2013 prohibition of manual scavenging and rehabilitation Act as the panacea, as something that could actually eradicate manual scavenging in India. This was official Supreme Court position. Later on, through my work and some other people's work, we've been able to point out that how that act itself has become the tool for further subjugating and invisibilizing the manual scavengers across, because definition in there excludes a person from being called as a manual scavenger the moment those individuals are provided with equipment, protective equipment, right? And now with the Swachh Bharat Abhiyan and the current scheme, Namaste scheme as well. The problem with the approach of the Supreme Court, and of course their policy, is that they're trying to constantly shift the ballpost from addressing the issue by total prohibition to trying to make it more acceptable, trying to whitewash it by saying, oh, they are more dignified sanitation workers. However, the issue of stigma doesn't go away. The issue of discrimination and untouchability doesn't go away just because the law says now you will not be called as manual scavengers or the derogatory and pejoratory term as bhangi, but what you would be called as professional sanitation workers. So that would be my response to that. Yeah. Oh.
There is one other question, ma'am, sir. Anyone can respond. So the question is, are there any limitations within the existing anti-discrimination laws when we view it from a Bahujan perspective?
Yeah, it's like, say, for example, if you look into the SC/ST Atrocities Act itself, it's like now one of the studies which is like proposed in my university is to study the misuse of SC/ST Atrocities Act. So in this doctoral committee, I was asking, has somebody studied about use of SC/ST Atrocities Act and why the complaints are very, very less under that, and why the conviction rates are very, very minimal, very like that kind of a minuscule level of punishment happening in that such cases. So then we need to look into how casteist our criminal justice systems are, how casteist our judiciary itself, because they see it as not a crime, they see it as part of the everyday life. So even if we have a legislation like that, how that itself is able to address the very question of structural discrimination and structural violences is very problematic. I think then we have to revisit and reread SC/ST's Prevention of Atrocities Act from the current point of view, and to probably we might have to come up with better kind of provisions, which is more facilitating to use, or probably to help us to use it in a better manner. Probably Asang would be, Asang can add more to it.
I think Professor Asang has, sorry, Doctor has left the meeting. Maybe he's in some other meeting. Ma'am, there are a few more questions. Are you able to see them?
Yeah, I'm seeing it now.
Yeah.
So I was kind of responding, are there any limitation within existing anti-discrimination when viewed from a Bahujan perspective? So I'm not completely able to answer that. My answer about the SC/ST Atrocities Act and lack of use, why people are not able to use it, why people are not getting conviction in such cases is itself is showing the limitation of it, and we need to reread and find more ample provision which is more usable and more facilitating. So that's what one response. Then if law is considered an instrument of justice, how do we explain situation where it reinforces social inequalities instead of dismantling them? So my point is that law is not an instrument of justice. It reiterates injustice. It stands with the people, those who are more powerful, those who are hierarchically more powerful. So law is like any state apparatus, it can be seen as an instrument of oppression. So it's not an instrument of justice, that is a fallacy. And we need to critically address the very instrument of law It's not always, it has a transformative potential to it. When we are when we talk about constitution in today's context, we talk a lot about transformative constitutionalism. That is one of the favorite area of D.Y. Chandrachud and all. And the question is, who has been transforming this constitution all these years? Are they judges? No. If you look into the history of transformative constitutionalism, all the case laws which we are citing as landmark case laws is filed by starting from Safai Karmachari Andolan to this Navtej Singh Johar and all. These are all the movements, those who are in the periphery of this country. Those who are organizing manual scavengers, they went to the Supreme Court to abolish it. It's not the parliament who decided to abolish it. It's not the judiciary who it can suo moto take cases and abolish this manual scavenging. But we have to wait for Safai Karmachari Andolan to go to the Supreme Court of India to fight the legal battle for such long years to come up with a new legislation. When Supreme Court finally had to say that you have to come up with the legislation, and SKA itself drafted that legislation, then it went to the Supreme Court, and Supreme Court suggested the parliament to adopt such a legislation. So you see, this is the pain of the anti-caste movements, and this is the pain of the organization which is organizing manual scavengers. And if you look into the all gender transformative constitutionalism case law, which is basically by NAS Foundation, it is filed by Navtej Singh Johar. These are all like trans movements who have been working for the idea of gender justice. This is not the parliament, the judiciary who acted as the agents of transformativism. That's what my point is. So we can see that this laws itself as an instrument of not of justice, but reiterating hierarchies and discriminations. And next question is in gap between legally formulated laws and their reality in effectively implementing it. When we connect this to the recent issue with Supreme Court of India abruptly banned the Class 8 NCERT textbook, which speaks on judicial transparency and delay. So when we try to do academic intervention in the court, tampering the freedom of speech and judicial transparency, without a judiciary acknowledging its flaws, how come it will reduce gap? Yeah, I absolutely agree with you, because I teach in a legal studies department. One of my recent PhD scholars, she submitted her thesis and got awarded on gender bias of the judiciary. And she had interviewed 32 judges all over Kerala. And then she did a courtroom ethnography, and she interviewed 10 of the women accused or convicted people, how judiciary differently treated them by multiple kind of methodologies, and it's such a strong qualitative work. And I see that how fearfully the academic institutions listen to such diseases, because they are not even ready to comment on it, because they're very scared. So that's why I was mentioning about academic freedom. And this NCERT text and all, it's the classical example of that. Judiciary never ever wanted to criticize their way of functioning and how they're functioning and identify their biases. They either it be their caste bias or gender biases. They're absolutely intolerant about it. So this is the scenario, and I don't know, I don't have really an answer, but I think to work more on such issues and even point out and expose it through our academic intervention is much more important at this context. And I hope you all will do such kind of, take up such kind of researches in future days.
There is another question. Please.
Ma'am, there is another question. I hope you can see it.
In the context of ongoing social inequalities, what role do we think students and young scholars can play in critically engaging with the legal system? How can they move beyond theoretical understanding to actively contributing to building a more just and inclusive society? Yeah, it's like there are multiple ways. One of it, currently, I have a student from a transgender background, and that person is a non-binary transgender person and wanted to work for reproductive rights of transgender persons and gender queer personalities. And what we are thinking is parallelly to file a case and legally contest this, parallelly doing academic interventions. And also I joined one of the cases in Supreme Court uh, as an interested, academically interested person. We can also join certain uh, court proceedings as interested people. That is one way. Another way is like to lobby with the parliamentarians, or you can even publicly engage with the most affected categories of people and discuss with them what kind of legislation they wanted to do. So one of the works which I worked with, funded by National Human Rights Commission, I was working with the surrogate mothers when the surrogacy law was in the process. Because the entire parliamentary process, the parliamentary different committees it went through, they were hearing a lot of IVF experts and the IVF people having infertility and all. They hardly discussed with any of the surrogate mothers. So I wanted to voice their voices because they are the silenced one in that category. So you can be the voice for the most marginalized sections in the society, either through organizing them, either through creating new movements, or through your own academic work, or being part of litigations. There are multiple imaginative ways. So I don't want to limit it by saying that you do research only, do research on it. There are other ways in which can complement to your research as well as the better interventional possibilities. Or even you can think of more collaborating with artist people and then do something, social media interventions. I think we live in a society, there are multiple ways in which one could intervene, not a single way. These are all complementing to each other. And I think Bimala and I met in Pune University. We were discussing about creating feminist archives. So one way to do is like creating new archives to do research, to create new histories for the most marginalized sections in the country. So there are multiple ways in which we can do that.
So are there any questions? So there is one other question.
From where do you think this is breakdown first? Is that the level of the police courts or due to prevailing social pressures? Also, in case such as bulldozer actions and hate crimes against Muslims, what has been the most effective legal intervention so far? If you had to identify one, what would it be? Surya, I don't know really how to respond to it because one of our research scholars recently done a work on the hate crimes against Muslim community, and she has developed a new legislation to address this. So the justice system breakdowns, I think, that happens from the level of from the ground level, definitely with police, courts, and the social system which prevails, the kind of social pressures. Like when we are discussing about, say, for example, if you take the case of rape cases happening in this country, and how many of the reported actual incidents of rape turn into actual reporting of the crime. And if you're familiar with the Varma Commission study, and it reports that 20% of the total rapes are being reported. Rest of the 80% of the rape is not reported. So imagine that 80% of the rapes, most of the situations, we are definitely sure that most powerful people might have done that. And the most vulnerable people definitely would be we cannot call it here survivor, but victims of such rapes. So 80%, we are living in a country where 80% of the rape is not reported. So we don't have any kind of social systems which supports a person of a sexual violence to report that to the police, in criminal justice system. And our criminal justice system is absolutely biased towards the perpetrators. If one of the studies in Kerala, which recently was talking about, when a woman who went through a rape experience, if she is willing and finally overcoming all social pressures and went to the police station, the writer in the police station never ever write it as it was the perpetrator sexually did a sexual intercourse which was not which was with force and not with my consent. For a woman, it takes hell lot of energy, whoever that woman be. It can be a Savarna woman, it can be a Muslim woman or Dalit or Christian woman. Then it takes hell lot of efforts and pain to go to a police station and make a complaint and say that this is what happened to me. So if you narrate whatever exactly happened to you, even then the police station writer will write, he has outraged my modesty. So what is it outraging the modesty? So it won't fall into any of the criminal category under the BNS now. So even from the writer in the police station to the judges. So judges in the recent PhD awarded my students' thesis, it clearly shows that how biased our judicial systems are when it comes to the gender issue. And I'm damn sure that the same study, if you could have conducted in the issue of caste question, it would have even more severe. So the judicial system and all, and for against the bulldozer system and crime against Muslims and all, I think we have no other way but to politically fight it back. And we have to have more solidarity platforms, more new allies to create a larger solidarity and fight back this kind of politics of hate and politics of violence. And I would like to say that the fascist politics of this Hindutva ideology, we cannot fight it back without having solidarity across the like-minded people who are believing in social justice and democracy. And that is the best way out, and all other studies and other interventions definitely will help to organize more people, attract more people to the allyship here.
Ma'am, what to do when the Supreme Court gives stay for some issues, but local government will implement certain things? In that case, what is there from the people side? For instance, I'm narrating this experience from my field actually. There is stay for the lands, but Telangana government has started doing some things, some constructions in that place, despite having the stay from the Supreme Court. So in that scenario, what would be the ultimate thing that people can do?
People have to agitate back and then fight it in on the streets, because
Yes,
you have
ma'am.
anyhow you have the legal sanction from the Supreme Court. Then you have
Yes.
every right to protest peacefully, or at times non-peacefully, I would say. You don't have to be peaceful always.
Yeah. Others, if there are any questions.
And if you look into any of the progressive legislation which we have in today's context, whichever country it may be, these are all are the outcomes of people's struggles and people's movements. It's not that one fine morning the state decides, okay, this is the kind of welfareism people required and giving that to it. No. If you look into the history of any single piece of legislation, including that of Constitution of India, is an outcome of nationalist movement. And particular nature of Indian Constitution is because of the Dalit Bahujan positions they have taken in the nationalist movement, within the nationalist movement, as well as in the Constituent Assembly. And any single piece of legislation, if you look into, either it be whatever they are demolishing now, any of the labor legislation, now they are bringing that as labor codes and taking away all the rights. So you can see that these are all the outcome of people's movements, workers' movements, women's movements. And this resistance and moves are the resistance and struggles are for to protect and preventing dismantling these legislations. Either it be farsighted movements or it be the workers' movements, we can see that. So whatever taken, they're trying to take it away from us. Now we are trying to prevent that through the large level protests, even CAA, all the larger movements you see, these are all to change the current legislation or whatever new changes they are bringing into.
Yes, ma'am. Thank you.
The current situation, if the judiciary is not providing justice in the to the people of India, how does one stay hopeful? My entire point is that judiciary is not here to provide hope or provide justice. That is through the movements we have gathered it. Look, if you look back to the history, you'll get that very vividly. So judiciary here has its own class bias, its own caste bias, its own gender bias. I urge you to read Mohan Gopal's essay in that book, which clearly talks about, he talks about two oligarch communities, which has been as judges in Supreme Court. 80% of the Indian judiciary comes from four major communities. Four major powerful upper caste communities. So it shows that the very nature of court, right? Very nature of judiciary. So why do you want to rely hope on such a judicial system? The justice, the very idea of social justice, which we can change the democratic practices of our country through our own interventions, our own political intervention, our own social interventions. So my suggestion is don't ever rely or don't ever rest your hope absolutely on the judicial system. Yeah, right now what they're doing is they're trying to even take away the constitutional provisions. If they come, this Hindutva ideology-based union government comes next time, the first thing they're going to take is changing and rewriting our preamble of the constitution. So if your first place, if your constitution is not there, what kind of justice are we talking about? So, and state is also, why are you taking state as a value neutral entity? State is also state has its own biases, its own ideological biases. State is not at all a neutral term. State is also always having an adjective to it. What kind of a state? Is it a colonial state? Is it an imperial state? Is it a welfare state? Is it a socialist state, or is it a capitalist state, or is it a crony capitalist state, or is it a Brahmanical crony capital state like ours? So our state is not a value neutral state at all. Every state has an adjective to it. That adjective shows its ideology. That's why Althusser calls it as state as an ideological apparatus, right?
Yes, ma'am. Thank you so much. It was really an engaging discussion. So you have helped us to connect law with the empirical evidences that you have drawn from your students, as well as your own experience in teaching law, as well as guiding the students. And I now invite Triveni for the formal vote of thanks.
Thank you all for the wonderful questions, and I'm so delighted to have this conversational. And I hope we could continue this conversation in some other platforms and continue. And probably, Vimala, you could share my number and contacts to those who are interested to continue this conversation.
Yeah, sure, ma'am. Sure.
Thank
Thank you.
Ma'am,
Triveni,
if
for the
you
formal.
want to, like, you can put your mail in the messages, maybe, like people can mail you. Yeah, Triveni, you can continue.
Yes, thank you, ma'am, for joining us on a special day. So today is Jaipal Singh Munda's death anniversary and 99 years of Mahad Satyagraha, which is a very significant day for Bahujans, and the day which laid foundation for human rights and human dignity. So thank you once again, ma'am, for joining us. I also thank all the participants for joining us and making this discussion insightful. And I thank BSF-HCU for conducting such discussions. I expect BSF-HCU also to conduct such discussions further. And I also thank ma'am and request you to join in further discussions as well. Hope you will join with us in future also. Thank you. Thank you, everyone and all. Thank you for joining us.
Thank you all. Thank you so much.
Thank you,
Thank you,
ma'am.
ma'am, for accepting our invitation.
If any one of you wants to have queries and clarification, you can mail to Asang sir. Asang sir asked to mail him if any of you have doubts. Thank you.